It's 5:30, so we'll call to order this meeting for Monday, December 16th, 2019. Carl, can I get a roll call, please?
Councilmember Remley.
Here.
Ronayne.
Here.
Lunsman.
Here.
Rife.
Here.
Johnson.
Here.
Lunsness.
Here.
Olson. Rux.
Here.
Mayor Schoeneman.
Here, please stand with me for the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next, we'll need a motion to approve last week's minutes for Monday, December 9th.
So moved. Second.
Got a motion from Rux and a second from Remley. All in favor, please say aye.
Aye.
Opposed, nay. Motion does carry. Next, we've got open forum. No speakers have signed up, so we will move right along to old business. First order of old business is ordinance number 19-12-04, establishing the number of regular full-time positions and their position titles and fixing the bonds of city officials and employees for the upcoming year. Possible second reading and final adoption of ordinance 19-12-04. Lynn, do you have anything to add to what we know already?
No, no changes from first reading. I ask for your support for the second reading.
Move to approve. Second.
Got a motion from Johnson, a second from Rife. Do we have any questions about this or statements before we take a vote? Otherwise, Carl, give me a roll call vote, please.
Councilmember Remley.
Aye.
Ronayne.
Aye.
Lunsman.
Aye.
Rife.
Aye.
Johnson.
Aye.
Lunsness.
Aye.
Rux.
Aye.
Mayor Schoeneman.
Aye, motion does carry. Next, we've got ordinance 19-12-05, ordinance supplementing the 2019 budget for various unanticipated projects, activities, and expenses. Possible second reading and final adoption of ordinance 19-12-05. Carl, what do we know about this one?
Thank you, Mayor. The only change from last week is a minor increase in the mosquito abatement budget after talking to Mark Hoven, Parks and Rec Director, about the various supplements. He did note that there were going to be purchasing a few more supplies yet in December, and he wanted to make sure that there was adequate budget there. So I would like to increase that by $3,500, more than what it was last week. It was $58,000. This year, this second reading will be $61,500. If my numbers are right.
You did your math in your head there?
Yeah. Did you see that?
Yeah.
Or did you hear it?
Smoke coming from the ears.
Sounds good. Can we get a motion to make, do we need a motion to make that change, Ron?
Yeah, you should amend that.
I'll make the motion to amend.
Second.
I've got a motion from Lunsness and a second from Ronayne to make an amendment to add a $3,000 expense for mosquito abatement, $3,000 and change. Can I get a vote on that? All in favor, please say aye.
Aye.
Opposed, nay. Next, we'll take the actual vote of the second reading. Carl, can I get a roll call? Or actually, I need a motion.
Approve. Second.
There we are. Motion from Ronayne, second from Remley. Carl, can I get a roll call vote on the ordinance itself?
Councilmember Rux.
Aye.
Olson. Lunsness.
Aye.
Johnson.
Aye.
Rife.
Aye.
Lunsman.
Aye.
Ronayne.
Aye.
Remley.
Aye.
Mayor Schoeneman.
Aye, motion does carry. Next, we've got two consent calendar items, various retail liquor, packaged liquor, and retail wine license renewals, as well as setting a date of December 30th for special one-day retail on and off liquor licenses for 4 different entities. Can I get a motion to approve the consent calendar items?
Move to approve. Second.
A motion from Remley and a second from Lunsman. Carl, can I get a roll call vote? Actually, why don't we just do it as a voice vote? All in favor, please say aye.
Aye.
Opposed, nay. Consent calendar does pass. Next, we've got several new business items. Ordinance 19-12-06, ordinance setting the fees and charges for certain services provided by the City of Aberdeen for the year 2020. Possible first reading ordinance 19-12-06. Carl, tell us about that.
Thank you, Mayor. We do this annually to set the fees throughout the year. Most of the fees have stayed static. I have underlined any changes to existing fees. You'll see that the ambulance rates were changed with the recommendation from Chief Meister. Excuse me while I get my glasses here. This is awfully fine print. Some equipment rates changed from the recommendation from Public Works Director Bob Zine. And then, as Lynn noted during budget discussions, we did change the solid waste rates because we are currently losing money through those operations, so we upped them by 50 cents per month. And what was it? Oh, the system development fees changed as well. As City Manager Lander discussed during budget sessions, we increased those. There are significantly more new fees that are included in this that were previously either internally in the different departments or that were addressed in the ordinance before the recodification. Those are double underlined. So they're existing fees but have not been included in this ordinance prior to this.
Okay.
Move approval.
Second.
Thank you, John. I got a motion from Bunceness and a second from Ronayne. Does anyone have any questions for Carl before we take a vote on these adjusted fees?
Do you have one on the specialty care transport? That went up significantly. Is that to help where we've kind of lost in the past or what? Because that's a big jump.
Yeah, and primarily that's to try and recover the costs that we have associated with that service. We typically lose quite a bit of money on that, and primarily because of the Medicare rates. You know, there's a cap on what Medicare will pay. So through other people that are using the service, we hope to be able to recoup at least some of that. This change won't make up the whole amount by any means.
Okay, thank you.
Mr. Johnson?
Just for clarification, I see under parking enforcement, the street sweeping maintenance fee is shown there, but at this time, removal of a vehicle for street sweeping is optional, correct?
Yes, and that's the one I forgot to address, was in discussions with the Public Works Director and with the City Manager and the Assistant Public Works Director, with the new contracts that we have for the different towing companies. We, at $40 a tow, we're losing money. I think Lynn calculated, was it $7 each?
Yeah, actually, the per hour went from $30 per hour to $35 per hour. If you average at least 4 tows within an hour, you can calculate what that would be. And then our per tow rate went from $40 per tow to $45 per tow. So if in fact our snow removal fee is at 40, you can see we're clearly losing money. Matter of fact, I calculated that last storm we lost $2,062 just from calculated fees, not including staff time. And so we're asking that it be changed to $60, and it has not been changed for 25 years or more.
Right, I read and understood that, but I'm looking at the third item down, the street sweeping, which would be not due to snowfall, but
Oh, okay.
seasonal. Right.
We've had some construction activity where it's necessitated that we go out and clean it up because they didn't have adequate equipment to clean up the mud associated with construction. And so we were trying to get a little closer to the actual cost of when you look at the machine and the man associated with the cleanup.
Okay. But just to reconfirm, street sweeping, leaves and stuff against the curb is done on a schedule, but there's no penalty associated for parking. It's optional to move the vehicle at this time.
Since we went to day.
Since we went to
sweeping,
daytime operations.
Is that right?
That's true.
Okay. All right.
That's correct. I misunderstood you earlier. I apologize.
Unless, of course, the car is there for successive times and, yeah.
Yeah, if you let your boat sit out there for a month, we'd probably take you.
So the $10 fee that we're talking about here was for something different? The street sweeping and maintenance fee?
That was the process for the nighttime sweeping. We would ticket you. We typically didn't tow, but it was a ticket for obstructing street sweeping.
Right.
The new process, we have not been ticketing and have tried to work through that process. However, if people are there for extended periods of time, there would be a chance that we would give you some kind of notice and possibly ticket if you're there all summer type thing.
And that's what that was your question was driving
Yes.
from?
It is. Mhm. Yeah.
Satisfied?
So there are circumstances where that could be levied, but typically it is not.
Typically would not be, correct.
And if I could elaborate too, this was kind of an experiment, wasn't it, the first year or two? And so I had lobbied that we not repeal this, that we keep this in place in case we have to go back to the nighttime maintenance again, then we would put this back in and ticket accordingly.
Yeah, if that decision were made within a calendar year. Okay,
Yeah.
that makes sense, I understand.
Councilman Bunceness, did you have a question as well?
Yes, going back to ambulance rates, was there a comparison made to set those rates the way they are? Did you look at other communities?
I can comment on that. I know that Chief Meister did do a survey of other communities, and that's where he garnered that information. So the numbers you're seeing in the ambulance rates and in the fire watch, or the fire nuisance fire alarms section, or the fire and rescue section, are based upon a survey of other communities. So those are in line.
Okay. Thank you.
Then also, back to the snow removal, how do we compare to other communities? Are we still below them quite a bit?
Yes, I checked 3 other communities, and we're significantly below what their obstruction fee is.
Typically, what are you seeing from those other communities?
$100. It's a deterrent in other communities.
This fee hasn't changed in my entire 25 years I've been here, so it was in existence before '94.
And that was the $40 you're talking, that it previously had been?
Correct.
All right, Carl, can I get a vote on that, please?
Councilmember Remley,
Aye.
Ronayne,
Aye.
Lunsman,
Aye.
Rife,
Aye.
Johnson,
Aye.
Bunceness.
Aye.
Rux,
Aye.
Mayor Shonneman.
Aye. Motion does carry. Next, we've got. Does everyone feel like dancing? We've got a.
I'll watch.
Okay. Wait till after hours here. Ordinance 1912-07, ordinance supplementing the 2019 budget for various activities and expenses. Possible first reading of ordinance 19-12-07. Carl, tell us about that.
Thank you, Mayor. I hope I'm not hoarse by the end of this evening. But actually, what this is more of a housekeeping measure. All of these expenses were originally included in the Parks and Recreation Gift Fund. It's labeled the 210 Gift Fund for internal purposes. But as we looked over the different expenses that were being paid out of that fund, they're not really gift fund in nature. That gift fund is supposed to be used only for donations and bequeathments. So a lot of the activity was more programmatic in nature and would be more appropriately accounted for in either the 208 Parks and Recreation Fund that they use for all their other activities, or in an enterprise fund. An example of that would be like for dance classes, where some other business may have a dance program where they charge the students, like Parks and Rec does. So we are putting those into an enterprise fund. So really, this is a shift of the budget from the 210 Gift and Trust Fund into the 208 Fund under Parks and Rec, or in a 614 Enterprise Fund under Parks and Recreation. It's more of a budget shift than it is a supplement, but because it goes to a different fund, we technically have to call it a supplement.
Move approval.
Second.
Got a motion from Bunceness and a second from Johnson. Does anyone have any questions about that adjustment? Otherwise, Carl, can I get a roll call vote for that ordinance, please?
Councilmember Rux,
Aye.
Bunceness.
Aye.
Johnson.
Aye.
Rife.
Aye.
Lunsman.
Aye.
Ronayne.
Aye.
Remley.
Aye.
Mayor Shonneman.
Aye, motion does carry. Next, we've got the petition to vacate public right-of-way for the entire 12.5-foot alleyway right-of-way between Lot 1 of Air St. Luke's subdivision and Lot 3 Haggerty's re-subdivision, commencing at State Street South and continuing east 50 feet to a point of termination in the 33 feet wide 2nd Avenue Southeast right-of-way adjacent to the same lots, commencing at State Street South and continuing east 50 feet to a point of termination 215 South State Street and 601 Second Avenue Southeast. Possible approval, denial of resolution 19-1201R to vacate the property. Brett, anything new with this?
Vera St. Luke's is requesting to vacate an unused alley in a stub portion of Second Avenue Southeast that's adjacent to State Street with the intention of platting it into their adjoining property and using it for parking. Planning Commission approved it at their last meeting. Staff recommends approval.
Move approval.
Second.
Got a motion from Bunceness and a second from Rux. Does anyone have any questions about this or comments?
This is the State Street Clinic?
Yes. It's where they removed that house here 6-8 months ago.
Thank you, Brett. Carl, can I get a vote, please?
Councilmember Remley,
Aye.
Ronayne,
Aye.
Lunsman,
Aye.
Rife,
Aye.
Johnson.
Aye.
Bunceness.
Aye.
Rux.
Aye.
Mayor Shoneman.
Aye, motion does carry. Next, we've got resolution number 19-12-03, resolution dissolving tax increment financing TIF District Number 3, possible approval of resolution 19-12-03R. Carl, what about this TIF?
Well, this is another good news dissolution of a TIF where the TIF has paid off all the project costs, so state law requires us to pass a resolution to declare it dissolved. And at a later date, yet in December, I will bring in some bills forward to transfer the money that's remaining in that debt service fund to the different taxing entities. With TIF 3, there's quite a few properties in there, so I'm not sure just what the exact amount is. I think I noted, what did I note? It's right there, about $35,000 that we'll have in there at the end of the year that we'll be able to distribute to the different taxing entities. And of course, next year, all that incremental revenue will be actual property taxes that will go to the taxing entities as normal property tax.
Move approval.
Second.
Got a motion from Remley and a second from Rux. Does anyone have anything to contribute to this discussion?
Did-
Councilman Bunceness.
How early was this paid off?
At least 3 years.
Well, because it was created in 2003, tax incremental financing districts can have up to 20 years, so it could have gone through 2033. I don't remember what the project plan
2023.
called for specifically, but you can see that we're quite a bit ahead
Carl,
of that.
do the math again.
Okay,
2023.
2020.
Because it was 2000.
Excuse me, 20.
But I don't think we did this TIF until
Well, this
disperse any funds until like
right, it was
2007,
created in
2008.
2003, but then there was an amendment that was done.
Okay. Because that's what you used to
I can't
pay for the
remember what year that
streetscape
was.
and.
Yeah, did the streetscape on.
Yep.
on Main Street.
Clint?
I know Lloyd Hodgen worked on it probably 2006, 2007 to do an amendment. That's what we used to help pay for some
Yeah,
of the
that sounds
streetscape
about right,
materials.
2008.
Okay.
Yep.
Because that's gonna say the original landscaping project happened after I was employed, so that was 2009 plus.
Yeah.
It's about 10 years old.
Carl, can I get a roll call vote, please?
Councilmember Rux,
Aye.
Bunceness,
Aye.
Johnson.
Aye.
Rife,
Aye.
Lunsman,
Aye.
Ronayne,
Aye.
Remley,
Aye.
Mayor Shoneman.
Aye, motion does carry. Next, we've got a hearing on the transfer of retail on-off sale malt beverage in South Dakota farm wine license, including video lottery license from Viente Incorporated, doing business as Black Diamond Casino, to Nueve Incorporated, doing business as Sea Express 8th Avenue, Suite 2 at 1202 8th Avenue Northeast, Suite Number 2. Possible approval to transfer the retail on-off sale malt beverage license, included video lottery license from Viente to Nueve Inc. at 1202 8th Avenue Northeast, Suite 2. I don't have it noted. If anyone would like to speak on this topic, otherwise,
Move approval.
get a motion from Remley.
Second.
And a second from Councilman Ronayne. Does anyone have anything to discuss about this before we get a roll call vote? Carl, give us the votes.
Councilmember Remley,
Aye.
Ronayne,
Aye.
Lunsman,
Aye.
Rife,
Aye.
Johnson,
Aye.
Bunceness,
Aye.
Rux,
Aye.
Mayor Shoneman.
Aye, motion does carry. Next, we've got review and discussion of the City Aberdeen drone ordinance. Speaking to us today will be City Attorney Ron Weger. Ron, you've got the floor.
Thank you, Mayor. This will be a riveting presentation, I can just guarantee it right now.
It's the nicest PowerPoint we've seen all night.
So I had been asked to provide the council with an update to the drone ordinance, specifically to see whether it has become redundant in light of recent federal enactments or pronouncements on drones generally. And so what I will present here is a kind of a review of where we're at and how the ordinance came in. I look around and of the when the ordinance was adopted in, I think, March of 2016, we now have 4 new council members. So this is not a bad opportunity to review this. And you can thank Marie for that little animation. So I had provided the council, and the council have each been given a copy of the ordinance as originally passed with, and then of course this comparison. And I wanted to start out by just showing the comparison, and we'll walk through the state, federal, and then our drone ordinance, and then go to this comparison again. But I wanted to make sure that everybody saw, and there was a slight change that we made in that if you'll notice that there's a blue box under not over non-consenting person. I have put a check mark there for FAA required. That's a little different than what you had been provided with the council action request, I believe. So as we sit here today, again, the ordinance was adopted in 2016. In 2019, there are no conflicting state laws. South Dakota, I think Mr. Bray was here a few weeks ago to say that there had been changes going on in South Dakota law that had repealed some of the underlying statutes involved in the drafting of and adopting of our ordinance. And there has been significant changes in South Dakota law. South Dakota Title 50, which is aviation, is undergoing a comprehensive modernization, as most of that title was enacted before the FAA even came into existence. So Chapter 13, which deals with airspace and operators, has been amended, and there were a number of statutes enumerating rights and liabilities, and those would be, for example, what would happen if somebody was injured as a result of a flyover, or what would happen if a contract was being executed in an airplane as it was flying over the state of South Dakota, those kinds of things. Chapter 13 was amended to repeal some of those. However, the statutes prohibiting reckless operation and operation while intoxicated were retained. One could argue that those are activities involving with the airspace itself and operators within an airspace, and the state of South Dakota did choose to retain those statutes. Chapter 15 is actually a chapter that was adopted since the enactment of the 2015 ordinance, and it was passed in 2017 regarding drones, but it really has nothing to do with what we've been dealing with, and it has to do primarily with prohibitions against flying drones over correctional facilities. So again, the state is picking and choosing when it wants to become involved in navigable airspace. And then SDCL 50-15-2, again in the drones chapter, does require that any drone shall comply with applicable Federal Aviation Administration requirements, and I point that out for the purposes of our discussion of our ordinance later. So as we sit here today, then we look to federal law, and preemption is a legal term of art about whether one superior authority can preempt the laws of an inferior authority. And you can imagine that it starts at preeminent is federal, then state, then local. And so if the FAA, if the federal government has enacted laws that are intended to occupy an area, then those would preempt any lesser authorities' laws, state or local. And what we're seeing here is that the FAA has not expressed preemption language in its final rule. And the reason for that is it realizes that it needs to co-regulate with state and local authorities, and it wants to do so on a case-by-case basis. And I quote this language for you so that we can all see that the FAA has not pronounced itself definitively as the authority in these issues that we'll be talking about. The FAA is not persuaded that including a preemption provision in the final rule is warranted at this time. Preemption issues involving small UAS, and that's unmanned aircraft systems, necessitate a case-specific analysis that is not appropriate in a rule of general applicability. Additionally, certain legal aspects concerning small UAS may be best addressed at the state or local level. So the reason I have this in here is so that if anyone tells you that it's clear that the FAA has spoken and is occupying this entire area, it's absolutely not true. It's inconsistent with the way they are interpreting their own regulations. There was a case, and I have that pointed out, Singer versus City of Newton, which is a district court decision, which talks in reality about that preemption claim. There's two kinds of preemption. One is where the entire field is preempted, and when that is not true, then it's issues. It's called conflict preemption. The district court decision said that it's clear that the FAA has not occupied the entire field of airspace, and that states and local governments need to address whether individual issues are preempted and would conflict.
Is this a federal district court?
This is a federal district court. Not surprisingly, there's a number of case law dealing with the old pre-drone technology, and that is clear about whether states can regulate how aircraft are at that time, airplanes. The case law has not in any way caught up yet with drone technology and with the specific issues that drones would present for local governments. Unlike an airplane flying, thousands of feet overhead, what the law has not caught up with. What do we do with these drones that are literally right over our backyards or out in parks or being used for commercial activities? So this is important to realize that there is no blanket federal preemption. And the FAA has tried, kind of peeked its nose in the door sometimes, peeks back out, and depending on what context it's trying to pronounce something, whether it's in an advisory circular, which is something we'll talk about later, whether it's actual regulations, whether it's some kind of a informative release that they're providing to the public, they waffle a little bit depending on what their authority is. So the point here is that the federal statutes do not preempt this area. Aberdeen drone ordinance borrowed heavily from an ordinance passed by the city of Chicago. As beautiful as that ordinance was, I'm sure you guys all accepted that I didn't write it. A lot of it was taken from the city of Chicago, which was kind of leading the charge at that time. And Chicago, like us, is a home rule city. What I found interesting in looking at that, trying to look at the update, was that the state of Illinois, for some reason, has passed laws saying that they will now have the exclusive right to regulate drones. But they exempted municipalities of more than $1 million because they didn't want to touch Chicago's ordinance, because they know it's a good ordinance and want to keep it in place. The FAA has not challenged that ordinance, so as we sit here today, the Chicago ordinance, which is the grandfather of our ordinance, is still in effect. And here's our ordinance, and I provided everybody with a copy ahead of time, but I wanted to put the whereases up there because I wanted everyone to see that this was something that had been considered, that there were public policy directives here that were in play, that there was a balance of wanting to both embrace the technology and realize that it could have some great economic opportunities and recreational opportunities, but however, take into account the possible abuses that could follow. And so that's why I've included the whereases, just so that we're all acclimated to there was an actual history involved here. This was a process when we adopted this in 2014, starting in 2014 and resolved it in 2015, where we worked with the FAA. This wasn't done in isolation. I had a spirited discussion and debate with FAA representatives because they were trying to tell us at the time that they have that authority. And when I would challenge them on certain aspects, it was clear that they didn't have that authority. So that's all has come into play into the whereas language that you see in the ordinance. And now, starting in section 10-1 dealt with definitions, and 10-2 talks about the actual operating regulations. And one of the things that we started out by saying was this is for hobby and recreational purposes only. We do not touch Part 107 registered licensed drone operators, any commercial operator who uses it. Farmers would all be accepted. They're all Part 107. Photographers, those kinds of people who use it commercially, all get a Part 107 certification, and they are in no way impacted by our ordinance. This is only for the recreational drone user. And this is a good time to talk about why the drone ordinance has been helpful in a couple instances. I've had people call me and say that I'm wanting to buy a drone for a friend or a relative or a birthday. What can we do? And the ordinance has been a good place to talk to them, explain to them the public safety kinds of concerns, where they can and can't operate, and I've had no negative responses to that. I've had 3 telephone calls with people that have all gone very positively about that. So the first is that you cannot operate a drone within 1 mile of our airport and within the non-precision approach area. That's 10,000 feet area. And this is the map that we prepared for that. It looks like a big old fat balloon here. It looks like it takes up everything. It doesn't. As we go through and talk about what the no-fly zone is, you'll see that it's a small part of the southeast corner of the city. So then we have a provision that says you cannot fly it over any person who is not involved in the operation of the drone, and that's just a common sense thing to protect people who are minding their own business and do not need a drone within their bodily space. You cannot fly it over vehicle traffic. You cannot fly it over property that the operator does not own. You need to have permission within our community to be flying it over people's backyards and near their bedroom windows. Number 5 talks about that we did establish that you can't fly them over city-owned property, but we allowed for two exceptions. One is to cross from one authorized property to another using our streets, roads, or other rights of way. And another is that we specifically identified 4 large properties, large city properties within the city that they would be allowed. And they were Northwestern Holding Pond, Baird Park, Riverside Memorial Park, and Coonert Arboretum. And those are on this map. What I did in the last second was I superimposed our no-fly zone over where we are allowed to fly. And you can see that the no-fly zone is in that southeast quadrant is not a large part of our city. It's right on the edge of our city. And that the areas that we're seeing up at Northwestern Nature Area and Coonert Arboretum, those are the areas that are allowed that drone flights are allowed. And in fact, here is the signage that we have, that we've placed around the city. Doug Johnson was thrilled to get these up and get these in place. But we have the red signs, we believe, at city parks that aren't on the permitted areas. And then we have the green signs on areas that you can fly. And so people are able to know exactly where they can. And when I tell folks, here's where you can fly, that's not been a problem for anybody. Then going on with the drone ordinance, on number 6 there, a child under 13 years of age who is not accompanied by a child's parent cannot fly, or an adult. So a child under 13 does need to be accompanied by a parent. Number 7 is you cannot fly it at an altitude higher than 400 feet above ground level. We are a Class G airspace, which is what the Aberdeen area is. So that would be applicable to the Aberdeen area. Number 8 talks about flying outside of the visual line of sight of the operator. That's prohibited, and it just makes sense that whoever's operating the drone has to be able to have visual sight of the drone at all times. Number 9 says that it has to give way to any manned aircraft or a moving vehicle. So if there's a game of chicken, it's going to lose, and it'll lose by the ordinance as well. Number 10 is cannot fly in the dark time between sunset and sunrise. And again, some of these can fall under the rubric of careless flight. that if you're flying at a time when you can't see, then we can assume that you don't know where that's going to go. If you're flying under 11 under bad weather conditions, then that's can be dangerous. Number 12, you cannot fly over open air assembly units, and that means soccer games and where people are congregated in large numbers. Law enforcement building, those kinds of things. Number 13 talks about within 500 feet of electric generating facility. Again, it makes no sense to allow drones closer to those kinds of structures. 14, you cannot conduct surveillance unless you're expressly permitted by law. And this gets into the voyeur invasion of privacy type of language that a city has clear authority on. Number 15, again, this is for, you cannot operate it while you're intoxicated. This is consistent with state law, and this is essentially putting in making it clear what careless or reckless operation would be. 16, you can't equip it with a firearm or other weapon. 17, you can't intend to use it in a way that would cause harm to persons or property. And 18, of course, is in a reckless or careless manner. So this is the restrictions or the limitations of our ordinance. The construction talks about that if an operation is authorized by the FAA, then you can do it. That we will not interpret this inconsistent with what the FAA's rules are. Number 2, we will not, if federal or state regulation prohibits something, then we do too. So these are deferential provisions to in no way be inconsistent with federal or state law, and this is consistent with that statute I pointed out to you in South Dakota law that says that we cannot operate inconsistent with federal law. So what we've seen recently in the 2018 FAA Reauthorization Act was some changes. At least that's the way the FAA has postulated them as being some changes. And in May of 2019, so this was approved and signed in October of 2018. Approximately 8 months later, the FAA issued an advisory circular, is what it's called, and started identifying what it is that they feel are clearly within federal law. Number 1, cannot fly in a controlled airspace, and because the Aberdeen Regional Airport is an uncontrolled airspace, this doesn't apply to us. You must fly responsibly. And then they say that they will implement, community-based organizations. That's what CBO means, but they will implement standard safety guidance, but they haven't done it yet.
So does any of this have the force of law today? Is that?
Well, that's where it's unclear. It might have force of law, but I don't know the FAA recognizes that yet. Because some of this is actually in its regulations, and when they become part of the federal regulations, they are forcible as in law, and at the same time, the FAA isn't necessarily treating them that way. So we have you have to maintain unaided visual sight. You can't fly under the influence of drugs or alcohol. These are what they're saying are the general umbrella types of requirements that you would need to be flying responsibly. And then they have, down at the bottom, you'll see they have additional provisions that they're adding, and that's register and mark your drone. And then they're going to implement drone knowledge testing, similar to what a Part 107 certificate is, but they haven't done that yet. And for those of you who would be interested, there's a website that talks about where you can go and see that. So this is the magic FAA Advisory Circular 91-57B, which was promulgated and published in May 31, 2019. So it's roughly 6 months old. And this provides for the exceptions for limited recreational operations of unmanned aircraft. What I've been told is that typically the FAA uses advisory circulars in a non-advisory capacity, which is you will do this, even though they call it an advisory circular. This, however, is different. This is in fact an advisory circular because, as you can see, as we go through the document, they're saying that this is not legally binding. I have highlighted at 1.1 in red the very language from the actual advisory which says this guidance is not legally binding in its own right and will not be relied upon by the DOT or the FAA as a separate basis for affirmative enforcement action or administrative penalty. So what they've done is they've said that this is loose enough where we're not sure that we want to do this, but here's what we're going to put out there for guidance, for an advisory to the people. And so what I'm reading here isn't something that I've typed in. This is their own advisory circular. Okay. Excuse me. And I've lost
The other part in that says, regardless of whether you rely on this guidance, you're independently required to comply with all existing laws.
and what those are, we're not sure.
Yeah.
And the FAA is willing to defer to local authorities on a lot of that stuff.
Ron, can I make a quick statement
Yeah.
about this advisory? They also had a similar advisory in 2016 that has many of the similar statements within it, and this was an update from that 2016, but it still says it's an interim, not completed. So this is the second advisory circular we've had from them.
And I will also, in defense of people who are wondering where are we at on this, I can see why there'd be some confusion because the FAA keeps putting out stuff, and then they follow it up later with something else. And now what we're looking at here, to me, would be their last pronouncement on this. Whether something else will be coming out soon, I have no idea, but this is their last pronouncement. And it acknowledges that operators flying unmanned aircraft can endanger other aircraft, people, or property. And this is the reason I highlighted this is just to say that this is exactly the kinds of concerns that our council had 4 years ago when they enacted the ordinance. And this says that you should follow community-based organizations and their safety guidelines, which of course have not been developed or implemented yet. But in the meantime, this provides interim guidance on statutory conditions and basic safety guidelines.
What would be a community-based organization?
A community-based organization would be, for example, the Aberdeen Modeliers Club or whatever. I'm not sure what they're called, but those are the CBOs that they're talking about. They're not talking about communities. They're talking about CBOs. We have an aircraft model aircraft club, and the Modeliers, and those would be a CBO. And they do have a set of safety guidance. And they're a wonderful organization that's well organized, but they have not yet been given the strength of law by the FAA as far as their guidance. Okay. Oops, I'm sorry. I wanted to. So what you have here at 7.1 are actual statutory conditions that the FAA is identifying through their regulations. And we'll see these are underlined. And again, this is their language. Strictly for recreational purposes, and that's what we have. Aircraft is operated in accordance with or within the CBO set of safety guidelines that are developed in coordination with the FAA, not yet developed. Aircraft flown within visual sight of the person operating. Aircraft is operated in a manner that does not interfere with and gives way to any manned aircraft. 7.1.5 doesn't apply to us because we're none of those. We are Class G airspace in 0.6 here, so you cannot fly higher than 400 feet above ground level. 0.7 talks about having to pass a test that has not been implemented or designed. 0.8 talks about registering and marking your drone. So those are the statutory conditions. That's it. 7.2 says that here's what they're going to do, which is wonderfully appreciated, but they haven't done it yet. And this is just kind of a summary of what they felt their new changes. And again, this is from a document, a press release that they put out. This is not my language. This is theirs. So they've put it in a summary form. So that brings us. And by the way, I just wanted to point out, this again is their last language. The FAA is incrementally rolling out these features and requirements, so they haven't delivered us a nice package all tied up in a bow. So here we come back to our table, and I just wanted to point out that our ordinance touches on these 18 items, and obviously it's because it's ours, everything is checked. Under FAA required would be those statutory conditions that we talked about. So we've got 5 items that I think we can arguably check off as FAA required out of our 18 that we want. And then the FAA advisory from the circular would appear to include these other items as well. So what I'm trying to give you is something that shows that the ordinance that we have is comprehensive, deals with a lot of issues. Many of these flesh out in some degree what it means to be operating in a reckless or careless manner, but also that include what is allowed for purposes of law enforcement activities, like you may not have a weapon attached, you may not surveil other people. So there are concerns that are addressed in the ordinance that are not concerns that the FAA likely will address. And here's where I want to make clear. The FAA says specifically that it will not, and that it'll leave to the local authorities enforcement of issues like trespass and invasion of privacy, which to me are major issues and major holes in where the FAA's authority is. I mean, it's like they want all but not any of the tough stuff. So the last thing I wanted to show was kind of just to poke the FAA a little bit. They've got a helpful release dealing with what they view the role of local law enforcement. And they would like the local law enforcement to assist them in promoting voluntary compliance of their regulations. And each one of these 6 items that I've got listed here for what they like law enforcement to do is accompanied by about 2.5 paragraphs of what it is that they want. So they would like law enforcement to identify witnesses, identify operators, and review and record the event, identify sensitive locations, notify them, and collect all the evidence, and then stand back and let the FAA decide if they're going to do anything or not. So that's where it comes from where the citizens of Aberdeen would or would not look to the FAA for what they feel are violations of either their privacy, their safety, and their property rights. So that's what I put together as by way of an update, and the summary of this is that the FAA is hopefully going to get there, but they're not there yet. And in the meantime, I see our ordinance as being a lawful and proper role for our city to perform at this time.
I'd like to ask the chief, have we had any complaints with drone activity?
I don't recall any recent complaints. However, when we started looking at this ordinance, there were several examples of drones that were causing invasions of privacy. One person alleged an assault. So the timing of this ordinance and when we talked about this was
dial it all the way back to where it
pretty
says,
decent, and it did help us.
no-
After the ordinance, I can't think of anything that comes to mind where we've dealt with a particular issue.
Ron, can you educate me a little bit? There's you said these rules apply unless you fall under, was it 107?
Right, for commercial operators are required, and by commercial drone operators.
And so that's a separate licensing process?
Separate. And so if anybody is going to operate a drone for purposes of making money, then they would have to get a Part 107 certification.
This would just more regulate the ones you buy like at Walmart or Menards or whatever that you buy, you give to your kid and, oh, here you go, let's go fly this. Not something like, let's say, an advertising agency or
Farmer, for instance.
a farmer, they do a lot of crop surveys and that they do. This would not regulate that at all.
I'm showing this particular picture because this is, in my mind, what you would see more along the lines of a recreational drone. Even this is a high-end recreational, I think. But when Maria initially put this together, she had some fancy drones that I know were clearly commercial. And so this is something that's probably more along the lines of what we'd be talking about with our ordinance.
Would you dial back to that page? So one concern that I've got, because this blanket statement says, it specifies that there's certain legal aspects that can be addressed by the local government. And I agree that there are. In fact, I'd say that a lot of our ordinance falls within those things because in what I've researched, essentially local governments can do 3 things. They retain the authority to regulate their own use of drones.
They can prosecute drone operators for violations of general applicability, and they can regulate the use of drones within their jurisdictions through the police power, such as getting warrants, voyeurism, nuisance ordinances, attaching firearms, etc. But what they cannot do, and what this thing doesn't say that they can do, is regulate airspace, regulate flight altitude, flight paths, etc. Those fall within the dominion of the FAA. Now, the flight circular that we continually refer to is geared towards people, the drone operators. I handed everyone an issuance that the FAA put out towards local municipalities, which very clearly states in real-world common English parlance, state and local governments are not permitted to regulate any type of aircraft operation, such as flight path, altitude, or navigable airspace. There's 4 areas within our existing ordinance which do that. Within section 10.2, we've got bullets 1, 4, 5, and 13, all very specifically violate the regulation on navigable airspace. So I think that the ordinance would be perfectly fine and acceptable, banning things like firearms and so forth if we were to strike these things. But I think until we do that, I think that we're at odds with the FAA's
But that was
regulations.
if you note that that was under an old guidance, and this new advisory circular says the model aircraft operating standards dated January 11th, 2016.
That's geared
canceled.
toward the users, not towards municipalities. In the very specific
So
instructions towards.
there's nothing here that says what they can base this on. The Context Unmanned Aircraft System, Public Health Jones, Department of Transportation's Integration Pilot Program, but it clearly is not saying what
I don't
it
believe
is.
that the
but it
advisory
does-
circular says that a municipality can regulate airspace. I've never seen anything that would allow for that.
Well, it does say we can regulate landing sites.
Sure, and that's not airspace.
And we can
So
just sit
these
there and
things
say you
are-
can only land drones in certain locations, but.
Sure. And that wouldn't be an issue, in fact, because you're always in control of the landing space. So I think that when we had the map that showed the entire city of Aberdeen being white, in fact, would you page to that?
Sure.
I think it would be more fair to make the entire thing red, except for the tiny little bit that you might own as a property owner, because that's truly the only place that you'd be able to fly it if you're a recreational. It wouldn't be all the white space, because someone else owns 100% of that land, except for whatever parcel that you might personally own.
Permission from
Yeah.
the other person, you can fly it in
Mhm.
someone else's yard.
But that's, I mean, people are trying to take photographs and so forth. We have every right, I believe, and besides, I mean, whether or not people are doing it for one reason or they're getting permission, I don't think is really the topic. I'm saying that the man that worked for the FAA came and told us we had no right to.
What was that man's official title? What division did he work for?
He was a flight traffic controller.
Okay, well, that's far from the administrative end of what we're dealing with here on these advisory circulars.
This is simply a
It's one
matter of principle
person's-
for me.
One person's opinion.
Well, this-
And we're dealing with many opinions here.
The FAA put out this press release
You
that
don't even have the
specifically.
law. You have the press release that makes reference to a law that there's no circular for the law.
The circular is geared towards the individual pilot. There's quite a bit of documentation saying that. I just chose to print that one because it came directly for the FAA and it was specifically geared towards local governments. So I thought that was very applicable. I might be in the minority here. I'm willing to accept that. This is a matter of principle only for me. I'm a Part 107 pilot. I can fly all around town without permission. But I don't believe that we have the authority to do that. They are very clear about that. If you guys disagree, then I guess.
Without more information on what that authority is for and what exactly certain things are for all we know, this could have been under that old model aircraft operating standards, which is now canceled, which this wouldn't be applicable anyway, because they were working on standards.
Clint, it says FAA statement, federal versus local drone authority. It's specifically talking about the UAS operators.
But again, if you go and it says that the old standards that they were working on in 2016 are now canceled because this advisory circular is now there, what it is for the user. So, like I say, you just don't, there just needs more information on this. You can't sit there and say that, hey, you can't do this when you don't have any information for that.
I didn't say it, the FAA specifically said it.
May I ask a question?
Please do.
Ron, I'm going to direct this to you. If the mayor is right and we don't have any business regulating some of this, what is the effect? Does that put us in jeopardy? Does that make us subject to, I don't know, civil money penalties for legislating someplace where we shouldn't? Does it do anything else?
Well, first of all, we're not legislating in an area that we don't have the right to. As a home rule, we're within our lawful authority to draft this. I'm reluctant to say that there would be any kind of a monetary damage. What I will tell you is that you have an ordinance that's many parts, and in a court, when addressed with the ordinance, will try to uphold those parts that it can't. Let's use, for example, paragraph that puts in place the prohibition within 1 mile of the city or of the airport, and says that you can't fly in the city unless you get permission, but it does identify these areas that you can. That case that I had talked about in the 2017 case, City of Newton, they did just that. They dealt with individual provisions of the ordinance and addressed those and decided if one provision was too broad. For example, they required that every drone be registered by the city. And they said, you can't do that, and they threw that out. They also had what they've coined as a restriction of any drone use and a wholesale ban on drone use in Newton. And they said that's too broad, and they struck that. However, at the very end, which I found interesting, was the district court telling the city, of course, nothing prevents Newton from redrafting the ordinance to avoid conflict preemption. So they could come back and identify areas that don't result in an entire ban. The fact that the city, and we actually talked about this and worked through this when we adopted this, when we identified areas within the city, and we gave there was a quadrant. Each quadrant had its own area. We were trying to make sure that there was a viable alternative for people. And so that's what a judge would have to decide. Did we go too far even when we allow 4 areas of the city that you can operate in? So the idea that we're clearly in violation of federal law, I disagree with that.
The reason I brought that particular press statement instead of a pile of legalese was because it's something we can all understand. Reading that, it's clear language, it's in terms that we can all understand. They put it out. That's their perspective. The man brought it to our attention. I think it's our obligation to look at that. If you want to disregard it, then fine.
Some of us like the legalese, though, because then we can reference it back.
So, I mean, for me, it's, with Ron going through his presentation and with what you've provided, Mayor, it's not clear to me. I mean, it seems confusing. One place they say this, the other place they say something different. So to me, there is no clear direction here. So if we have to provide more to help me with that, then, or help anyone else that's maybe not clear about this, then maybe we need to do that.
There is a legal counsel number on their FAA's website. Our district is out of Chicago. We can clearly reach out to those individuals and find out what FAA.
So why wouldn't FAA take on the city of Chicago? If that ordinance is still standing today, and the argument is that ordinance, because it's the same ordinance as ours, is in violation of FAA, why hasn't that anything been done? And that would be the easiest spot to start. And I don't.
Do we know that it is? I mean, we heard that in this presentation, but I haven't seen, just like you haven't seen the legalese of the actual law mandating our ability.
The person that wrote the ordinance is sitting right next to you, and if you said it was the city of Chicago, then I'm going to believe him.
But you said it's still in operation. I don't know that maybe it's been repealed.
So, Ron, do you know if it's still in operation?
It's still in operation.
The other question I have, though, is I know some of the stuff that you mentioned here is we can't regulate altitude. Is that more directed toward we can't say they can go 500 feet, right? We can mirror theirs or bring it lower, but we can't bring it higher than theirs. And if we don't have an ordinance that specifies something, how do we enforce it? We're not going to enforce the federal law. We can only enforce the local law. So we would have to divert this over to a federal authority who, if they went 500 feet, the last thing they're going to do is fly here and tell somebody you can't fly 500 feet. We need some teeth in order for us to do something here locally. If we want to regulate it, we have to have a local law which mirrors the federal law at the 400 feet. So and again, and maybe we need more information before we can say one way or the other, but that's what I read in here, is that we can't bring that above what the federal law states.
It
And
says
we
we're
have to
not
have
permitted
something
to
do.
regulate.
We're not regulating. FAA is, we're just mirroring what FAA says. So we're really not regulating. The federal law is technically.
We're giving us
regulating.
ourselves an enforcement capability,
Correct. That's the way I see it.
because the FAA isn't gonna enforce
Is
it,
that
so.
how it
we-
works?
We're doing two things here. We are supplementing. We are not and will not regulate in conflict with the FAA. So if they said 400, we couldn't say 500 or 300. So we're supplementing it by by fleshing out what it means. And then secondly, as Clint pointed out, we're providing an actual enforcement mechanism here, the ability to do something about it, which is what the FAA does not want to do.
Sure. Well, could anyone argue with the idea that we should reach out to the FAA, their legal team, and just double check that their press release is invalid and that we are able to regulate navigable airspace?
Can I weigh in on that one? The FAA lawyers are good lawyers. I mean, they understand what they have the authority to say and what they don't have the authority to say. I had this conversation with them in the lead up to the adoption of the ordinance. They understand preemption. They understand where it gets fuzzy. What they've told me then is not going to be anything different from what they're telling me today, that it's still fuzzy. And they're going to encourage us not to do this, but they can't say that we're actually getting into areas where they have spoken clearly and exclusively. So I will be honest with you, I did not contact FAA legal counsel to basically have them tell me the same thing, that they want us to not do this, but they can't really tell us to stop it.
Well, my only concern is that their press release very specifically says we're not permitted to regulate. So if that's either no longer valid, it was never valid, it was a misspeak on their part, or they'll tell us, one way or the other, they tell us, though, what the circumstance was.
The case-by-case deference that they want, the referral to let's let each issue fight its way in the courts, that's where they want to be. So the press release that they would have given is helpful, but it's by no means something that they're going to defend in court.
And that is, like I say, they've had other stuff the FAA has since that press release that they have released for information, because the advisory circular is 531 of 19, and it preempts numerous other things, so we don't even know I mean, like I say, I'm never against getting more information, but the press release is from July 2018. They could just be now that, no, we don't care if you regulate within the boundaries of what you have the power to regulate.
So why not ask, is my point.
And Ron can, and we're not saying he shouldn't.
Here's what I will say is that this is something that both through the City Managers Association and the Municipal Lawyers Association continues to be a front and center item. If we see changes and more clarity from the federal government on this, we'll certainly bring it to the council's attention. And if we see that we have something that we know is unlawful, then we will ask the council to either amend or repeal.
You know, I agree with the mayor, though. It doesn't hurt for us to make the inquiry, and if this, I don't know if a drone is an aircraft operation. I don't know if that's what this press release is intended to say. Maybe it is, maybe it isn't. But if you would, I think it would be helpful, Ron, if you take the time to call those law slingers in Chicago and see, is that where they were?
It was, yes. For
Yeah,
our
and see
district.
if they will clarify that for us. I think that would be helpful.
Travis, I'm looking at the comparison here, the sheet with the Aberdeen ordinance, the FAA required, and the FAA advisory.
Sure.
there's a few that the Aberdeen ordinance is checked, right, and the FAA required and the advisory are not checked.
Right.
Of those, if you narrow it down to that, which one of those do you have the issue with? Is it the flying over someone else's property? Or what?
Yep, so number 2 would fall within that, that dominion of airspace. Some of the 500 feet of electrical facility would, over the property of others.
And there may be other federal laws with the FAA. I drove by electrical facility and it actually had no operation of aircraft within so many feet. So, you know, because they had higher power lines and stuff like that. So,
So just to give everybody a little bit of a background on the way that the commercial drones operate now, even the one that was, the DJI model that was included in the beginning of this presentation would be the same way. They're all GPS driven, and in order to fly them within several miles of an airport, you need to go to the FAA's website, punch in your product information and what you're going to be doing with it. So they've got a clearance mechanism, and in case something goes wrong, they
but
can
we're not
track it.
regulating those.
We're not regulating those.
We're not regulating commercial ones.
Well, the DJI one in the picture Ron said was a recreational one, and that would have the same operations.
Yeah.
So, I mean, short of the really, like the $50 ones that come from runnings during Black Friday, a majority of them are, I would have to think, are operated the same way, where they're GPS driven through your mobile device. And that's the case. It pings through a system that requires authorization for flight within a considerable amount of distance from an airport. We recently flew over the 3rd Avenue Bridge for a project, and we needed to push clearance through the FAA in order to even have it lift up off the ground.
What would be my remedy if there was a drone 5 feet above the ground in my backyard with a camera looking around?
Well, that's the other things that, like, it prohibits voyeurism, and that was, I believe it was a federal issue as well. But I think we're plenty well covered for the sake of privacy through the drone, aside from the use of regulating airspace. There's other bullets in this existing ordinance which
If you can't control a drone, the airspace of it flying to your property, how can you control it when it's in your backyard videotaping your kids? Because it would have to get there somehow. I mean,
No, but that's banned behavior.
If your argument is regulating airspace, that means all airspace, right? That means your backyard.
yeah, they could
Is
be
that-
above
is
my
that
backyard,
too
above the
Much
treetops.
of a simplification of that argument?
No, and that's, and again, in defense of the FAA, that's where the technology has outpaced the law, because when it was airplanes, that was never the question. But now suddenly airspace arguably is a quarter of an inch above the grass. And I know the FAA is trying to feel its way through these processes right now.
You know, if someone wants to have Ron make a phone call, I'm not sure that it's going to change my mind. And I don't believe you're going to get a clear answer. And so I think this is confusing, and I will stand behind our administration in the forming of this ordinance. How many other communities in the state of South Dakota have ordinances that are similar?
Honestly, I don't know. I have not checked into that.
Okay.
When this one passed, and I took a stand against it, I was in newspapers across the entire nation because it was such an unusual thing for a municipality to be regulating drones.
So one of the things when we started this conversation, I think Lynn is the one that started this conversation because he saw, Christmas coming and all the big box stores that were going to have these cheap drones, not the more expensive ones, and I thought it was, what he did and what Ron did was, trying to get ahead of this issue.
No, I truly believe that the intentions were good. I think that there's maybe some good that's come of it already. I'm just saying I don't believe that we've got the authority to do those 4 bullet points, very specifically.
Could I just talk about history a little bit? Actually, was labeled as a hot topic of the Christmas of 2016 from the City Managers Association. And actually, California, I can't remember what city it was, put out model ordinances for the cities of California. And so at the time, it was so unregulated that there was so much uncertainty with it that, and as you can see today, there's still uncertainty with it, that the Cities Managers Association said, beware of possible problem areas associated to this. And I go back to the safety factors of, there was nothing within the original circular that talked about flying within populated areas, like at a football game or something like that. And I think we were trying to take it from a safety perspective of protecting people.
Yeah, I think it had very good intentions. Does anyone else have anything else to discuss on this topic?
And I stand like with Dave, unless, the FAA comes out, I think a lot of this stuff in here, and you could even mark off not buying an unaccompanied child under 13, because even in their advisory circular, you have to be over 13 to register your drone. And we could even put in there that says all drones have to be registered with the FAA, because that's what they say, is that all these drones have to be registered. But we don't even say that. So there are things that we could even add to the ordinance that would make basically any drone that, the kid out playing in the backyard whose parents didn't register would then be not applicable. But we don't even go to that point, because now that's an FAA, let them regulate that. But I think that there's a lot of good things with this. And like I say, I think, and I know people who have these, you'd be surprised how good some of those cameras are. And I know, for instance, in state parks, you can't fly a drone. And I know that because I know people who flew a drone in a state park, and the park marshal comes over, park ranger comes over, you cannot fly that here. So there are places that are regulating it in South Dakota.
Did they arrest you?
No, I wasn't flying it.
He's too fast.
Yeah. Well, I don't know if I'd go that far. But I mean, no, they told him to stop flying it, and of course he complied and put it away, didn't fly it again.
Did they ask for your state ID?
Yeah. Again, not me. I was just, I was over sitting around the campfire.
It looked a lot like Clint, but he had a fake mustache.
Yeah, I'm not going to say that on public TV.
Well, that was a good one. Thanks, guys. Next, we've got
Mayor?
Oh, yes.
I just have one other comment on this. Back in March of 2016, I thought we did a good job of collecting everything, and what we passed I supported, and I still support the points now. There was one recommendation I had back in 2016 that I would like to float again. When you look at the map showing the permitted drone flight areas, and we have the 4, and there's 1 in each of the quadrants. At that time, I proposed that we also allow the portion of the soccer complex, the soccer fields itself, to allow it over the grassy area, not to include the softball stadiums. And the reason I do that is because it's an ideal patch of level grass with no obstructions, and it would be unique. And I go there to fly kites with my kids. Yeah. I would, consider having a drone if that were allowed. The other options that a person has are not really that great. If you look at the 2 on the west side, both of those have marshy cattail areas. If a drone were to go down through operator error or battery failure, you might have a hard time even recovering that, just where it's going to land. The Baird Hill isn't even level. You're talking topography. There's almost no flat ground even to enjoy a drone flight there. And the Arboretum is okay, but it's very narrow. And so you're going back and forth, and you're not getting any sense of, capabilities of what a drone can do. And so I would, again, recommend that we consider allowing the soccer area, the grassy area there. It lies dormant almost every hour of every day, except during the soccer season. And then you would be governed by the existing points that we have. Outside of that, on a Saturday when it's not soccer season, I think that would be a perfect place. And so I would propose that we consider adding that to the existing allowed drone flight areas.
When this first came up, I thought that would have been an excellent area too, because there had already been people flying model airplanes there, but model airplanes that go much faster and higher are a little bit different than what these drones are. The issue that we had back then was the model airplanes were falling into people's houses and actually causing damage. And this was back in the mid 2000s. But you know, it's a nice, perfect spot for it. And as long as it's for drone type activities, and it's perfectly fine. That was when the Model Airs field south of that area was flooded and they couldn't get to it. So people made do with good flat pieces of ground.
Yeah, I think more the better. Good suggestion, gentlemen. Next, we've got the request.
Do you want,
What would be the process to make that addition or amendment to the existing drone flight?
just, if there's a consensus, then we could put that together with that change to that section to include that area. I will tell you that I know that Doug Johnson did have some concerns about the soccer area at the time, that maybe you might want to have Mr. Hoven come in and address the council on that as well.
I would take that step.
But I can prepare something and just circulate it as a draft and make sure that Mr. Hoven knows about it and we can set up a time.
Excellent, thank you.
I think that there's a different purpose, by and large, operating a drone versus operating a model airplane. I think it's less to control the flight of the thing as it is to get photographs and video, take nice images, and I think quarantining people to these little areas on the edge of town really limits, photographers' ability to capture images and so forth. Whether or not they're professional, I think, is maybe beside the point, but we'll find out what the FAA says. Next, we've got the request for property tax abatement for property in city limits. Possible approval of the property tax abatement as listed for property in city limits in the total amount of $180.14, with the city's share being $57.04. Carl.
So moved.
A motion from Ronayne. Was there a second over there?
I opened up my mouth.
We've got a motion from Riley and a second from Ronayne. Carl, can I get a roll call vote?
Councilmember Rux.
Aye.
Bunceness.
Aye.
Johnson.
Aye.
Reif.
Aye.
Mundsman.
Aye.
Ronayne.
Aye.
Remley.
Aye.
Mayor Shoneman.
Aye, motion does carry. Next, we've got the city's bills, approval of the bill list for December 16th, 2019, as seen on your screen. Can I get a motion to pay the bills?
So moved.
Second.
Motion from Johnson, second from Reif. Carl, give me a roll call vote, please.
Councilmember Remley.
Aye.
Ronayne.
Aye.
Lunsman.
Aye.
Reif.
Aye.
Johnson.
Aye.
Bunceness.
Abstain.
Rux.
Aye.
Mayor Shoneman.
Aye, motion does carry. Next, we've got the city manager's report. Lynn, what have you got for us tonight?
I have no report this evening, thank you.
Did you withhold it because our other discussion took too long?
No.
Okay, sounds good. Then I will take a motion to adjourn this
Moved.
meeting.
Second.
A motion from Bunsen, second from Johnson. All in favor, please say aye.
Aye.
Opposed, nay. We are